So before Kevin comes up and kind of talks about immigrant status, right? So just kind of recap. The idea here is you can either come to this country to be temporal, or you can come with the intent to stay long term. And that is the distinction between non-immigrant and immigrant visa status. So at some point you will make that choice. But for a lot of us in our community, we make that choice early. We make it back home. As students, our families sometimes just say, go overseas, go be a student, right? So you can be a tourist. Your parents come here, and then you realize, oh my God, I want them to stay. So the question here, which is what is addressed, is that distinction. Temporal, long-term. Temporal, long-term. So Kevin is going to address what happens if you decide you change your intent, right? You get here, like you said, and you decide, you know, I want to stay for the long haul. Or you're in Cameroon and you get the opportunity to come, like a DV. How does that work?
Like my colleague Mr. Fonan said, I'm privileged to be here to talk to you guys again. This is my second year of doing this. I thoroughly enjoyed it the first time, and I think it's going to be even better the second time. I thank my colleagus. We've put in a lot of work into preparing for this, and I really appreciate you turning out today. It does make it worthwhile, so I know our time wasn't wasted. Like I said at the introduction, I've done immigration law for a very, very long time. If I had to put a number of years on that, I would say about 8-9 years. So I think I know a little bit of what I'm talking about. My colleague, Innocent, just talked to you about coming here on a temporary basis. I guess we're all already here in the United States. So what really concerns most of us at this point is, how do I stay on a permanent basis? How can I go around driving my car without worrying about the police? You know, so that's the issue that most of us face here. How do we move from a non-immigrant status to an immigrant status? And just for the sake of terminology, I'm going to use the word LPR a lot, which stands for legal permanent resident, which also translates into a green card holder. So if I use those words, I'm talking about one and the same thing. Now, what's permanent residence? Like Innocent defined what a non-immigrant is. A permanent resident is somebody who's decided to remain here permanently. And the very first thing that I want us to take from permanent residence is that it's a privilege. It's not a right. Just like when you go and apply for a driver's license, they tell you your driver's license is a privilege. It's not a right. And what that means is you can lose it. If you do the wrong thing, you will lose that right. You will lose that privilege. So that's the first thing that we need to take. It's a privilege, it's not a right. So we have to conform ourselves in such a way that we don't lose that privilege. And to become a permanent resident, we have to show an intent that we want to remain in the United States permanently. Now, that doesn't mean that you have to give up some other residency. You know, most of us come from Cameroon. You can have multiple residences, but what the law is saying is you have to show that among those multiple residences, you've chosen the United States to be your permanent residence. And so the question is, how can we show that? So we're looking at our intent to reside versus our actions. Before I go into that, another really important aspect that I need us to remember is, each time you leave the United States, or each time that even if you don't leave the United States, if you're here, you have to continuously show that intent to remain here. It's not something that you do it in 2013 and that's it for the rest of your life. You might go on vacation, and on your way back at the airport, you can still be questioned about your intent to remain in the United States. So it's an ongoing thing. It's not a one-off. So we also need to remember that. Now, I asked the question, how do we show intent to remain in the United States? We're looking at our actions versus we look at our actions to portray that intent. So we're looking at things like paying taxes in the United States, many states. On the contrary, if we invest a lot of money heavily in some other country, that could be used as an intent of you not wanting to stay in the United States. So we need to remember that that could be a flip side. Staying outside of the U.S. for more than 1 year on a continuous basis without any break, that will be considered an intent not to stay here in the United States. Those are things that can affect your intent to remain here permanently. Family ties. You could be married with children, but you choose to keep your wife and your children or your husband and your kids in some other place, not here in the United States. That could be used as an intent of you not wanting to stay here permanently. I talked about filing taxes, so some people choose not to file taxes. All of those could be used as an intent of you not wanting to stay here permanently. So our actions is basically what is used to determine that intent of whether we want to be a permanent resident or not. Now, we've all expressed that intent that we want to remain here permanently. How then do we obtain permanent residence? And under the laws as it is now, there are two main criteria, or two main sections. There's what they call the selection system, which is basically a select number of visas that is given to a select category of people. There's also another group of people who are not subject to any limitations. That's basically a catch-all group where Congress from time to time can pass a law that can lump somebody into that group. So most of us might not fall under that group. During the Iraq War, I think Congress passed a law where if you had worked in Iraq as a translator for the U.S. Government, you could become a permanent resident. So it's under that category that they could just create a law and lump it under that category. It cannot come into the first selection system category. So those are the two main categories. And we're not going to talk too much about the second part, because unfortunately most of us might not come under that. So we'll spend a lot more time talking about the selection system. And under the selection system, we have three main groups as it is now. You have family-sponsored immigrants. You have employment-based immigration. You have diversity visa, which is the green card lottery. There's also a group for refugees and asylees who can also apply to become permanent residents after a certain period of time. What is a family-sponsored immigrant? Well, let's talk about some facts, first of all, about family-sponsored immigrants. 480,000 visas, family-based visas, are made available every year in the United States. And you could either be admitted as an immediate relative, and that's also another important term which we're going to define, I will define later, an immediate relative, or through the family preference system. So those are the two groups under family-sponsored immigrants. Now, just something that I like to talk about family immigration, because it's a good thing, and I think we all need to know that it's a good thing. It does help the country where we are. It does help the United States. It helps the economy. And these are actually studies which have been carried out and are proven. It helps the domestic economic growth of the United States. It contributes to the well-being of the current and future labor force here in the United States. It plays a key role in business development and in community improvement. Immigrants have been considered to be amongst the most mobile of labor forces here in the United States, because we come and we're ready to go anywhere. We can go to Montana, you can go to Michigan, you can go to New York, you can go to North Dakota, it doesn't matter. And they're highly educated. So being an immigrant, family-sponsored, employment-based, it's a good thing, and I think we need to hold up our head high and not feel ashamed about it. It's something which is available in the system. If you do it right, it's something to feel good about. And just finally, there's also something which studies have also proven. Most of our mothers come here and they spend time looking after our children. while we go out to work. As of now, the U.S. government has not been able to quantify the value of that into the U.S. society, but they agree that it provides a lot of benefit because it allows the younger folks, it allows us to go out and work. We know we have our parents taking care of our children, and that is an invaluable service that they provide. And all of that is recognized under immigration laws. And like I said, family-sponsored immigration is something that we need to be proud of. Now, I use the term immediate relative. What is an immediate relative? An immediate relative is a child. Let me just backtrack. I made a note here, and I really want to talk about it. A couple of days ago, I think yesterday, if some of you listen to the news, I think Missouri actually initiated a program where they're inviting immigrants to move to Missouri. And most other states have done that, and the reason is that they understand and they see the value of the immigrant labor force, and they try to pass laws that is attractive to immigrants. So these are all signs to show that family-based immigration, employment-based immigration is actually important and it's critical. So I made a note to mention that in case some of you didn't catch it on the news, but it's actually ongoing in Missouri. So immediate relatives. An immediate relative is you're either children or spouses or parents of a United States citizen. It has to be a United States citizen. Now, if it's a child and you're petitioning for a parent, then you, the child, must be a son or daughter, which is somebody above 21 years of age. So if I'm above 21, I'm a U.S. citizen, I can petition for my dad or my mom. That makes my dad or my mom my immediate relative under immigration law. I'm a parent and I have a child who is not a U.S. citizen. I want to petition for that child. That child must be below 21 years of age at the time I file my petition for that child to be an immediate relative to me under immigration law. I'm married and I lost my spouse. As long as we've been married for 2 years, and I petition within 2 years of my spouse's death, I could be an immediate relative to my late spouse. I don't know if you guys follow that. So I could be an immediate relative by myself. I was married to a U.S. citizen for at least 2 years, and I lost my spouse, and I filed a petition within 2 years. So I am an immediate relative. I can fall under an immediate relative classification. Also, we have the Violence Against Women Act, which was passed several years ago, which gave women a lot of benefits across board, including under immigration law. And it also made battered spouses or children or battered parents of United States citizens or even permanent residents. You could also be an immediate relative under immigration law. So under the VAWA, which is the Violence Against Women Act, if you're battered and you're a spouse of a U.S. citizen and a permanent resident, not just a U.S. citizen, you could be classified as an immediate relative under immigration law. So and the reason why immediate relative classification is important, which we'll talk about later, is that the other category of visas, which is the family preference system, the other category under the family-based immigration, there is a queue, there is a waiting period. And some of that waiting time can be as long as 5, 6, 7, 8, 9, 10 years. Whereas if you're classified as an immediate relative, there is no waiting period. And if you put in an application and you're eligible, then you can get your green card or you can get your legal permanent residence right away. So that's why being an immediate relative is critical. It's important under immigration law. Now, if you're not an immediate relative, obviously you come under the family preference system, which I just talked about. That's where they have different groups, different categories, and the different queues under those categories. Now, the first preference category is defined as unmarried sons and daughters of United States citizens. Now, notice it didn't say unmarried children, it just says unmarried sons and daughters of the United States citizens, and we'll talk about that later. Now, under this category, 23,400 visas are allocated, plus whatever is left off from the fourth category, which we'll talk about later also. And I talked about a priority date, Q, that I talked about. Each time, whenever you file, a petition is filed on your behalf, the date that the petition is received by immigration constitutes your priority date. Now, that date is important under the family preference system because it tells you what position you are under the queue. I actually have a picture of current priority date, but I think I did it for the employment base, so we'll take a look at that later. But the date that your application, the petition is received marks your priority date, and it's important because it marks your position in the queue. So right now, as we speak, the current priority date for that first preference category is September 15 of 2006. So as you can see, if you come under that category and you're filing a petition now, you probably have about 6-7 years to wait. Second category is subdivided into has two subcategories, and you have 114,200 visas plus whatever is left off from the first category, which is allocated every year. Now, the first subcategory under the second preference, these are spouses and unmarried children of legal permanent residents. So spouses and unmarried children of legal permanent residents. And of the 114,000 visas allocated under this category, this second preference category, 77%, I'm not very good at math, but that's a significant number, 77% is allocated to the spouses and children of legal permanent residents. And what I mean by current priority date is current simply means that the queue, the queue on this category is up to date. So if you file, and this is one of the things that the current administration has been pushing to get this category current, because a couple of years back this category was backed up for about 3-4 years. So which means if you're a permanent resident and you petition for your child who is still a minor, it will take that child about 3-4 years to get to the United States. But with the current administration, the queue has been cut to 0. So once you file the petition, that child becomes eligible to become a legal permanent resident. Now, the second subcategory under this second preference are unmarried sons and daughters of legal permanent residents. So not children anymore, but unmarried sons and daughters of legal permanent residents. And only 23% of the visas are allocated to this subcategory. And the current priority date for this category is February of 2006. You all understand what that means now. Our third category is married sons and daughters of United States citizens. And under this category, 23,400 visas plus whatever is left over from the first and second categories are allocated each year. And the current priority date for this category is January 22nd, 2003. That's even longer. The fourth category, brothers and sisters of U.S. citizens. 65,000 visas are allocated here, plus whatever is left over from all the other categories. And the current priority date for this, that's fine. You could be a skilled worker, which simply means you full-time permanent, you have a full-time permanent job that requires at least 2 years of training or work experience. Other workers are, I think I must have missed that. I think the first preference category is the only category where you don't need to seek any documentation from Department of Labor. Like I said, if you fall under that category, and you have your Nobel Peace Prize in your hand, you can just walk to the embassy, they'll give you your visa. If you come under any other category, you need to go through the Department of Labor to get what they call a labor condition certification application. Also, important in the second category, I'm sorry, I keep going back to that second category. People like nurses, they have certain professions which are called Schedule A professions. Schedule A professions are simply those professions that the Department of Labor has identified that there is a shortage, there is a critical need in the United States. So they give them some preferential treatment. And as of the last review, these are physical therapists, professional nurses, people in the sciences or arts, and people in performing arts. So if you come under, if you think you qualify, or you know people who qualify under those categories, again, these categories have special dispensation from immigration. They have a more streamlined process, and they fall under that second preference category. Now, going back to that third preference, the professionals and the skilled workers, you have to go through Department of Labor. Some people can get national interest waivers, which are basically waivers from the government saying that we need this person's skills here, so you can come under this category. Okay, under this category, it says work experience is no substitute for a degree. So if you come in under this category as a professional, then you have to meet the minimum requirement for a professional, which is the baccalaureate degree and your membership in a profession. So, like some of the other categories, you can, like a skilled worker, you don't have to have a degree. You can have work experience. But under this category, if you're classified as a professional under this category, you must have a degree. You cannot substitute the degree with work experience. So that's what they mean by work experience is no substitute for a degree. Now, moving on to the next category, which is the fourth preference. These are what they call special immigrants. And special immigrants are persons. Special immigrants would be people who have abandoned their permanent residency and for some reason decided to reapply for it and it's granted, so they can come back to the U.S. under this fourth preference as special immigrants. Also, religious workers can apply for immigrant visas and move permanently here to the United States. But they have certain criteria to meet. You must belong to a religious denomination with a bona fide non-profit organization in the U.S. So whatever religious denomination you belong to, they must have a representation here in the United States. And you must show that you've been there, you've been a member for 2 years prior to when you put in your request to move here permanently. And you must be coming here solely to perform in that ministry. You must have been working in that ministry prior to your application, and when they talk about working under the immigration law, they want work where you're paid for it. They don't consider voluntary work. So it has to be your permanent full-time work under that ministry. Now, if you're working as a lay member within a certain ministry, that doesn't count. You have to be working as in a religious capacity, which simply means either as a pastor or some kind of preacher. But you have to be working in a religious capacity, not a lay capacity. Also, under this fourth preference, they have visas for NATO workers or international organization employees. And so that's also pretty self-explanatory. Again, under special immigrants, you have court dependents. These are children who have been determined to be wards of court, or children who are going to be placed in foster homes or foster care. They can also be accorded permanent residency here. People who have served in the Army, 12 years of honorable service on active duty in the armed forces. service must have been after October 1978. You must have enlisted lawfully. You must have been outside the United States when you enlisted and under a treaty agreement between the U.S. and whatever country that you enlisted for. Also, I talked about translators with the U.S. Armed Forces. They can come under this category to apply for visas. Iraqis, that was a good one that I decided to put there. Iraqis providing faithful, valuable service to the U.S. So, if you're an Iraqi, you can come under that. Yeah, I'm done. Fifth preference, this is what they call employment creation category, and basically the main thing to take from this category is that you have to have at least $1 million or at least $500,000. If you have $1 million and you're prepared to invest it in the U.S. and create jobs where you employ at least 10 people, then you'll get a visa. If all you have is only $500,000, then you can invest it in specific areas. I'm sure right now if you have $500,000 and you decide to put it into Detroit, you'll get a visa because they need it over there. So if you have only $500,000, you can target what area you want to invest that money in, and that way you can get a visa. You can get a permanent visa to stay here permanently. So I think with that, I will wrap up my presentation. I know I've been trying to choke down a lot of facts down your throat, but there are a lot of facts in immigration law. Like my colleague said before, every case is unique. Every case is unique, but also there are many, many nuances. So my take home to you is talk to a professional. Talk to a professional. Give them your set of facts, and we'll try to plug it in here. There's always a way. It can always be done. I've been doing it for a long time, and I've had a lot of success with it, and I'll keep doing it. Thank you.